hollow remains hollow, I may be permitted.
We'll see at the end.
5 minutes. That is last.
Yes, doctor.
But on a point of levity, my lord. I said, on a point of levity, flattered though I am, but the only authoritative, my lord, jurists in this country are your lordships, my lord.
No.
One has to be absolutely clear about that. I want to apologize to your lordships.
This
my
was a
lord.
little bit of good neighborly behavior coming in from Aligarh. See, sir.
My lord, I interned with Mr. Sibal and I told him, tell me how 500 pages can be reduced to 3. If you can teach me that, then I'm prepared. Otherwise, I'm not. So he gave me lots of briefs to read, my lord, and he is my guru. My lord. So this side, I don't go beyond that to Allahabad. My lord, I'm sorry that I've interrupted, my lord, and I apologize. There have been 2 views, my lord, given about me, my lord. One is that I come out blazing, with all guns blazing. The other I found, my lord, the other day was, Dr. Rajiv Dhawan was the other senior counsel who made his own detailed submissions with a melange of legal acumen coupled with passion, thereby exacerbating the attack. I think this is good, my lord. Now, my lord, kindly, my lord, 1F, my lord, if your lordships will.
Yes. Excellent. Okay.
Upload नहीं हुआ.
It's on the screen. Okay, yes, sir. Sir, yes, sir.
But it's okay. But what I'm trying to say, you put everything in this.
Is it uploaded, my lord?
Yes.
Lord, in my reply, there are some questions that fell from your lordships, my lord. The question of indicia, for example, fell from your lordships. The questions, my lord, of surrender versus continuity has been argued, and therefore I have to respond to that, my lord. National character versus and excellence. Therefore, my lord, I'll briefly take your lordships through all that. If your lordships will just see the index first. This, my lord, is a mixture of what they have argued that I have to respond to, and some of the points, my lord, raised by your lordships. Now, my lord, much has been said about the scope of reference, and it has been argued that your lordships are just to answer the unanswered question in TMA Pi. My submission on page, is it, what would be the PDF? Page 2, my lord, is that the reference in this case, not having been delineated by the court, has to be abstracted, my lord, from the 81 reference, my lord, and more importantly, it has to be abstracted, my lord, from the 2019 reference. Now, my lord, on page 2, in 1.2, I say the reference is not on a single AC. And then, my lord, in 1.3, I have indicated what can be gleaned from the reference, my lord, in 2019. So the first point is, was Bhasha correctly decided? Does it suffer from internal contradictions and reasoning on facts and law? Aziz Bhasha is squarely raised, I won't read the reference again, my lord, is squarely raised as a point of reference, my lord. Aziz Bhasha needs to be reconsidered in the light of earlier and subsequent decisions, my lord, that we have argued earlier. I won't labor it. The effect of Aziz Bhasha on the future decisions of the Allahabad High Court, which applies Aziz Bhasha completely and strikes down the statutory character to the 1922 Act through the 1981 amendment. Is it a usurpation of judicial power I don't think I need to labor too much on this, my lord, because it's in my original written submission, my lord, with the various case laws that support it. Then, my lord, what is the effect of the National Commission for Minority Educational Studies? Now, the important point there, my lord, is it recognizes the rights of minority under Section 10, which I'll elaborate later. And finally, was Aziz Bhasha correct in accepting the antecedent historical data on AMU's Muslim character, but denying it constitutional significance while deciding the issue of minority status? And my lord, this is at variance with various decisions, and therefore it has been argued that in actual fact, the question, my lord, of antecedent data from their side has been argued, my lord, on the negotiations. We have said that, on the other hand, negotiations plus, my lord, the movement that started. In my respectful submission, reference to Macaulay in 1837, my lord, or even the Woods letter is irrelevant. What is relevant, my lord, is the 1904. That is what is relevant. That was a template that was indicated, and Banaras Hindu University and AMU are the exceptions to that template, and that has to be recognized. Then, my lord, I move on, my lord, that it's a question of appeal, my lord, on whether Aziz Bhasha, we've raised these questions relating to Aziz Bhasha, my lord, and therefore to say that Aziz Bhasha is not an issue, my lord, would be entirely incorrect. I won't go more than that, my lord, on this. My lord, the cross-reference of the appeal is CA 2286, questions 10, 13, and 14. This is squarely raised before your lordships, and there is no point taking a narrow interpretation that all that has been decided by your lordships is the unanswered 3A. This is broadly speaking on the reference, my lord. The reference is not singular, but the reference is multiple, and a mere reading of the 2019 reference will illustrate the various points I've indicated there. Now, my lords, I then want to go into the question, and the way I formulated it is minority rights before and after the adoption of the Indian Constitution. The reason why I say before, my lord, the 1909 Act recognizes the minority character of Muslims. In an electoral context, no doubt, but definitely the question of what constitutes a minority before the Constitution is squarely raised, my lord, in the 1909 Act, in the 1919 Act, and in the Government of India Act. Later on, my lord, one other minority is added, that is Sikhs. Therefore, minority status, my lord, is something that was known before the Constitution. It isn't a question that arises only after the Constitution. Certainly, my lord, the courts were aware and the relevant provisions, my lord, of the particular statutes, my lord, I'll indicate later. After the Independence Act, my lord, there are 2 points that have been mentioned by your lordships. The first is the dispensation of Article 30. That's, my lord, an important, and the second is the dispensation of the UGC Act. Now, what prevailed, my lord, after the UGC Act, in essence, is also prevailed, my lord, before the Constitution as well. Had this minority character not been recognized, my lord, there would have been no partition of India. So coming up, my lord, from 1909 all the way to the Constituent Assembly debates, we see that the minority character is fundamental, my lord, to our understanding of what was there before the Constitution. Now, my lord, let me take my lords through that portion of my submission on page 6, my lord, PDF 6. I've indicated, my lord, in para 2.1 that the Indian Councils Act, 8 out of 27 elected members were reserved for Muslims. This is definitely an indication of the concept of minority before the Constitution. Then, my lord, the Government of India Act, I've indicated that in the upper house, out of 34 members in a 60-member house, 10 were to be elected by Muslim separate electorates and 1 member for the Sikhs. Then, my lord, in the lower house, out of 104 who were elected in a 145-member house, 30 were Muslim constituencies and 2 were Sikhs. And then, my lord, the Government of India Act, the upper house out of 156 in a house of 260, that's 104 to the rulers of the Indian states. 104 were given, my lord, to the general electorates, 49 for Muslims, 6 for SC, and 4 for Sikhs, 6 for women, and 2 for Christians. Then finally, my lord, in the Federal Assembly, out of 250 seats, out of 375, Muslims got 82 seats, 24, my lord, at that time, and obtained nearly 30% of the 33% of the seats. The point I'm indicating to your lordships, my lord, when Nehru was asked in July 1946, will you yield the question of political representation? And he said, we'll do nothing of the sort. And that is the turn that takes place, which leads to partition. So the issue was fairly and squarely there. After the Constitution, your lordships will just have a look, my lord, at 2.2 on page PDF 7. On the positive side, my lord, 25 to 28 guarantees, including freedom of conscience, right to freely practice, profess a religion, right to establish charitable institutions, and non-interference in religious affairs or imparting religious instructions. Your lordships had mentioned 29.2. The reconciliation between 29.2 and 31 is you can't discriminate to the other people. That's 29.2. But you can discriminate under 30 for your own people. Then, my lord, on the negative side, my lord, I want to mention the importance of 2 aspects. The non-discrimination aspect is one aspect. And, my lord, the positive part is Article 30 or 25 to 28. So I've indicated that Articles 15.1 and 16.2 are the negative part, dealing with discrimination. You cannot discriminate on grounds of religion. But Article 15.5 and 15.6 is important. I'll just read that portion out. 15.5, my lord, ends with the underlined portion, other than the minority educational institutions referred to in clause 1 of Article 30. So, my lord, this exception is an important exception. Therefore, not only do you get constitutional recognition, you also get statutory recognition. And likewise, my lord, 15.6 on PDF 8, it says, other than minority educational institutions referred to in clause 1 of Article 30. So, my lord, statutory recognition is given as far as Article 30 is concerned, as far as 15.5 and 15.6 are concerned, my lord. And constitutional recognition, of course, is there in Article 30 and 26. Parliament has accepted that minorities have a right to establish and administer a university by virtue of the National Commission of Minorities Act. The definition, my lord, in the National Commission of Minorities Act is inclusive. And then, my lord, after the amendment that was made, it includes universities. 10A, my lord, says a minority educational institution may seek affiliation to any university of its choice, subject to such affiliation being permissible within the act under which the said university is established. When we come, my lord, to the other statutory recognition, pramati, at 2.4a, We, however, hold that the 2009 Act, insofar as it applies to minority schools, aided or unaided, is covered by Clause 1 of Article 30. Pramati arose in this way, my lord, whether certain aspects applied to the minority or not. And Pramati was absolutely clear it does apply to the minority as well. Then, my lord, the Central Educational Institution Reservation of in Admissions Act like 2002, which also provides for reservations in higher educational institutions.
This is an exception for mine.
And an exception is carved out, my lord, once again for minorities. So I'm looking at present, my lord, in the constitutional dispensation and also, my lord, in the statutory dispensation. That is the voice of Parliament clearly saying that minorities are accepted in 15.5, 15.6 and the various statutes. Now, my lord, the concept of minority goes to the root of minority protection under the Indian Constitution, which has been recognized as a basic feature of the Constitution and its secular framework. Now, secularism, my lord, as understood by your lordship's judgments, one of the important components of secularism is, in fact, minority characters and their protection. Now, my lord, in Pramati, a very interesting point was made by quoting, my lord, the former Chief Justice Sikri. And what he says, my lord, here, after quoting from Justice Sikri's judgment in Keshwanand, I won't read out that particular paragraph, my lord. Thus, the power under Article 21A of the Constitution vesting in the state cannot extend to making any law which will abrogate the right of the minorities to establish and administer schools of their choice. Now, my lord, the suggestion made by Chief Justice Sikri was in fact that you can't even amend the Constitution as far as Article 30 is concerned. Then, my lord, the concept of minority education goes to the root of minority protection, which has been recognized, my lord, I've already said that. Over the page, my lord, we've already read these portions out to your lordships, that minority institutions is consistent with the doctrine of equality. Once again, my lord, Justice Kripal has been cited, and my lord, Justice Khanna. Respondents suggested that an affirmative action of AMU's minority status would be contrary to the public interest, as it would be. I'm sorry, my lord, my learned friend wants me to read the bit, my lord, in TMA Pi. Article 31 ensures protections to the linguistic and religious minorities, thus preserving the secularism of the country. So there is a connection between secularism, and an attempt was made to treat secularism and give it a narrow meaning. Minority protection, my lord, goes to the heart of what secularism is about. And, my lord, consistent with the doctrine of equality. And in St. Xavier's, my lord, the portion, my lord, which we have underlined, special rights for minorities were designed not to create inequality. Their real effect was to bring about equality by ensuring the preservation of minority institutions and by guaranteeing to the minorities autonomy in the matter of the administration of those institutions. The differential treatment of minorities by giving them special rights is intended to bring about an equilibrium so that the ideal of equality may not be reduced to a mere abstract idea, but should become a living reality, and the result is true genuine equality, and an equality not merely in theory but also in fact. Therefore, my lord, the point I'm making, my lord, in this segment of my submission is there is a constitutional premium as well as a statutory premium which is attached to minority exceptions and the minority dispensation. It is not just Article 30, but if we go through the statutory dispensation, then it will become quite clear. Parliament has also come in to say we accept the minorities from 15.5 and 15.6. Now, my lords, I come to page 11, my lord. My lord, the argument really on their side has been surrender, and on our side has been continuity. It is ultimately, my lord, left to your lordships to finally decide whether there was continuity or whether there was a surrendering. And in our respective submission, my lord, at 3.1, it is undisputed that MAO College and their affiliate bodies are the nucleus of AMU. Now, much has been said, my lord, about the determination of fact which cannot be removed. In actual fact, there is only one and one only, my lord, aspect of fact, my lord, is that the MAO College and their affiliate bodies are the nucleus of AMU. That is the fact that was decided by Aziz Bhasha. And even if we accept their argument that facts cannot be changed in a reference which I believe is incorrect, my lord, there is facts and law, there is facts and there is law. All of them, my lord, come under the dispensation of Bengal immunity. So when you look at all this in Bengal immunity, which is the stare decisis point, my lord, when you look at them, certainly the foundational aspects of Aziz Bhasha can be re-examined. And therefore, this subtle distinction about facts not being the subject matter of appeal or reversal is not correct. Now, my lord, here the statement of objects and reasons in the preamble shows that the Muslims intended to convert and incorporate Mayo College and its affiliate societies into Aligarh Muslim University. That, my lord, you'll just see the statement of objects and reasons. The Muslim University Association, having requested the foundations of a university and certain funds and property being available to this end, it is proposed to dissolve that association of and Muslim MAO and to transfer the properties to these new bodies. Now, my lord, in the preamble, my lord, it also says a teaching and residential university and to dissolve the Mohammedan Anglo-Oriental College, Aligarh, and the Muslim University Association, and to transfer and vest all their properties. It is for your lordships to decide whether the surrender argument, my lord, is an accurate argument, or is it that it was a continuity? And as far as continuity is concerned, we have mentioned in 3.2b, Lord, 4.1 and section 4.2, assets of the MAO and its affiliate bodies in their entirety were transferred and vested in AIM. That is an argument of continuity. It's not an argument of surrender. Then, my lord, section 4.3, reference to the MAO College or its affiliate bodies in any enactment prior to 1920 will now be construed as AMU. That is an argument also, my lord, in my respectful submission, of continuity. There is no surrender involved. Obviously, one phase finished and a new one started. But the continuity is very much a part of this process. Then, my lord, section 4, references to AM College or its affiliates bodies in any will, deed, or other document will now be construed as AMU. This is an argument of continuity. Then, my lord, section 7, donations received, including 30 lakhs collected by the Muslim community, is to be kept as a reserve fund. That too, my lord, is an example of continuity. There is no surrender involved, my lord. The Act is absolutely clear that these are provisions of continuity. See on the top of page 12, my lord. All employees become employees of AMU. Now, your lordship is aware in service law, when this transfer takes place, it is not an argument of surrender, my lord. It's an argument of continuity. And most important, the objects of MAO College, promotions of Islamic learning and special provisions for Muslim students have been incorporated in the 1920 Act. Section 5.2, my lord, we have read all these before to your lordship, so I'll just quickly run through them. 5.2 on the promotion of Oriental and Islamic studies and instructions in Muslim theology and religion. 5.12, furtherance of art, science, and other branches of learning, including professional studies in technology, Islamic learning, and Muslim theology. The proviso to Section 8 says the power to exempt women, which is very much, my lord, an aspect of continuity. Section 9, compulsory instruction in Muslim religion for Muslim students. And then, my lord, this of course was later on deleted. Establish intermediate colleges and schools within the vicinity of MA College and provide instruction in the Muslim religion and theology. This is precisely what was taking place, my lord, before the 1920 Act. Then, my lord, 27J can make statutes for the instruction of Muslim students in Muslim religion and theology. This too, my lord, is a continuation from the spirit of MAO. Then, my lord, the 1920 Act ensures complete non-interference in matters affecting religion or religious instruction. For instance, the proviso to Section 28 provides that the instruction of Muslim students in the Muslim religion and theology did not require submission and approval that was ordinarily applicable under Section 28. Then, my lord, students, and this is the most important example, my lord, of continuity, that existing students in the MAO College would become the responsibility of AMU, including provisions of instructions as per the prospectus of Allahabad University. So now this can only be an argument of continuity. It cannot be an argument of surrender. It says those students who were there will come now in the dispensation of the AMU Act. And then, my lord, Statute 21, the registered graduates was to contain graduates from other universities who had been educated for at least 2 years in MOA College. This is an example, once again, my lord, of continuity. Now, my lord, the next is Aziz Pasha squarely accepts that the existing MAO College, this is a quotation, was made the basis of the university and was made over the authorities established by the 1920 Act for the administration of the university, along with the properties and funds attached to the college, the major part of which has been contributed by Muslims. Then it is true that clear from the 1920 Act that the nucleus of the Aligarh University was the MAO College, which was till then a teaching institution under Allahabad University. The conversion of that college, if we may use the expression, into a university was, however, not by the Muslim minority. It took place by virtue of the 1920 Act, which was passed by the central legislature. The fact that it was based, this is another, my lord, finding of fact that it was based on MAO College would make no difference to the question as to who established Aligarh University. Then 23(2). Also, my lord, the error in establishment, which we already argued, so I'm not taking your lordship through it, that the mechanism, my lord, was the 1920 Act. '22 Act didn't call for any surrender. It was just a mechanism by which you converted MAO, my lord. And then, my lord, the annexure to 1920 gives the name of foundation members. I'm instructed, my lord, and I've seen that particular list of trustees. All 124 were trustees in MAO. So they thought this was not possible, but there were 124 trustees. Then, my lord, the annexure foundation members, I will not go there. And then, of course, in the 1920 Act, no person other than a Muslim shall be a member of the court, which of course was changed, my lord, in 1951. Then, my lord, as I indicated to your lordships, there is a limit to which imperial history such as Macaulay's Minutes, 1837, Wood's Dispatch and Hunter Commission report have significance in determining the minority character. It is not necessary to go into Macaulay's understanding that the idea was to reproduce Englishmen, nor was it necessary to refer to the Hunter Commission on recognizing degrees. Now, my lord, there's a very interesting, my lord, book on Napoleon. And Peter Gale, who edits that book, says we can go into history as an argument without end. And this is what has really happened. One side citing what they believe is surrender, and we citing what was the mood at that particular point in time as explained in the various provisions and the background. What is relevant, my lord, when we look at parliamentary history is not these background factors. What is relevant may be the speech of the minister, the select committee, and parliamentary debates. All the rest of it, my lord, are not relevant except as an exercise in mood making. And there has been so much of a difference between what we argue, that an entire movement took place, and their argument of surrender. Because what we've argued is there was a movement from the original college and then schools, and then it culminated in the 1920 Act. So, my lord, the question of surrender did not arise at any point in time. It is a play on words, nothing more than that. Surrender always sounds like a stronger word, my lord, than a movement. But there was no surrender at any point in time. And this argument, my lord, is entirely and totally a play on words and nothing more than that. Then, my lord, through a selective reading of the material on AMU's historical antecedents, the respondents have argued that the minority Muslim community surrendered the denominational character of AMU. The 1920 Act, read as a whole, along with the statements of objects and reasons in the preamble, clearly reflect on the denominational nature of AMU. The legislative debates are unequivocal to support this view. So, my lord, the education minister, I've given the references, my lord, I don't want to read all of them out. The education minister, when introducing the AMU bill, narrated the entire history of how AMU came into being from the foundation of MAO College to negotiations with the Muslim university for its conversion into a Muslim university. The education member also used the phrase Muslim university and stated that it will be of immense benefit to the Indian Muslims. Then, my lord, I referred to Khan Bahadur's Miss Asad Ali Khan. Though we are first in the field of launching out a scheme for a teaching and residential university on denominational lines, our sister community, which started much later than the Banaras scheme, achieved their objects sooner than us. The Raja of Mahmudabad, this will be the second denominational university in this country. I'm making this point, my lord, because it is really, really very important, because that was a major argument, my lord, canvassed almost right throughout the day, that these are arguments of surrender. You look at it from another point of view, eventually, of course, your lordships will have to decide it. On page 16, sorry, where?
3.6.
Sorry, the Raja of Mahmudabad, then, my lord, PDF 16, my lord. At the time of passing the bill, the education minister stated, "My lords, today your excellencies, government is committed to the custody of the Muslim community, a priceless trust, the incalculable benefits of which will be enjoyed not only by themselves, but also their children and their children's children." And the Governor General says, before putting the question, I'd like to add my congratulations to the Muslim community on the passage of the bill. Now, this being an important point, my lord, eventually your lordships will decide and look at the debates and the so-called items of surrender. I think they're irrelevant until we reach the 1919 bill. They're completely irrelevant, because ultimately it is that bill which was converted into an act read as a whole that will determine whether it is a surrender or whether it is a continuation. I've already made that argument. Now, important question, my lord, which is consistent with their argument of what is the indicia of a minority. And my lord, the Chief Justice said, please delineate those particular. So I'll read it, my lord. For one, the question of indicia of the minority is an issue which squarely arises from the issue number 3A left open in TMA Pi and quoted in the reference order of 2019. We, my lord, have divided the indicia into two parts. The first, my lord, is factors which are relevant to be considered, which are indicative of the minority character, and factors which are not determinative of minority character of an educational institution. The determinating factors are founders should belong to either the religious or linguistic minority. The community must be numerically less than 50% of the total population in any state. This is TMA Pi, my lord. This is the numerical test. Historical antecedents to the judge of the institution which show the active involvement, intention, and contributions of minority founders or the community. So that, my lord, is taken straight from St. Stephen's. Their argument that if Stephens were allowed to, were invoked, my lord, to determine the minority character, my lord, then the historical antecedents would clearly show that the contributions was active involvement, intention, and contribution of the month. Now, my lord, para 8, it was argued that there's nothing in the statute. It may not specifically may not mention the fact that Aziz Bhasha was being overruled. But para 8, and I must bring it to your lordship's attention, para 8, my lord, clearly goes against Aziz Bhasha. I'll just read that again. Article 31 has been construed by this court without referring to those cases. It is sufficient to, what is this? To say that the clause contemplates two rights which are separated in point of time. The first right is the initial right to establish institutions of minority choice. Establishment here means the bringing into being of an institution, and it must be by the minority community. The next sentence is important. It matters not if a single philanthropic individual with his own means founds the institution or the community at large contributes to the funds. Now, it is our submission earlier, to which there is no reply, that even if one single philanthropic person were to contribute and other contributions were made, funding, my lord, would not be an issue, whether it's 100% or less than 100%. It is of no consequence whatsoever. The position in law is the same, and the intention in either case must be found to found an institution for the benefit of a minority community by a member of that community. It is equally irrelevant that in addition to the minority community, other than from other minority communities, or even from the majority community, can take advantage of these institutions. This, my lord, gets us into the question that there were several interpretations in Aziz Bhasha of whether it means establish or not. And this now, my lord, effectively indicates that the issue is one of founding, and it can be by one individual, contributions can come from other individuals, and it would not make no difference to the minority character. Then, my lord, over the page. I'll skip 4, my lord. Constitutional documents such as state, statute, rules, or regulations read as a whole should show the predominance of the minority community. That's St. Stephen's. Administration of the institution, if it's vested in the founders or persons in whom the founders have faith and confidence. Now, this is an important point, my lord, because you needn't have found it. The idea here being that it must be of people in you have confidence. And this is important because I may put people in the operative institutions But as long as I have faith in the founders, and the founders and others, my lord, in this stream of events, my lord, it is their faith and confidence that is important, not 100% this way or that way. Then imparting of religious education or providing of religious institution and worship, this is, my lord, also a point that goes into indicia. And then symbols such as the name, architecture, motto, and other cultural symbols of the minority. Now, in Allahabad, my lord, there was about 2-3 volumes of the architecture, the invocation to God, the invocation to Allah. And this is repeated in St. Stephen's because they say these are also indications and part of the indicia of minorities. Now, factors which may not be determinative. Incorporation or establishment by or under a statute. This may not be determinative. Recognition of degrees may not be determinative. Receive of grant and aid, funding from members outside the minority community, quoted with approval at TMA Pi, para 109 and Patro. Role of government or its regulators to prevent maladministration. This goes to the heart, my lord, of the role of the oversight of the rector or the visitor, as the case may be. I made a distinction earlier between what are the oversight provisions and what are the administrative provisions in the statute. So even if we say these 3 declaratory provisions were in fact ruled out, the rest of the statute will certainly show the minority character. Then, my lord, regulation for promoting excellence. Your lordships will see that because it's an important point in only this sense that, and I'll come to the national character, my lord, later. How can it be that when you promote excellence to the highest point, which is of national character, how can it possibly, my lord, in my respectful submission, my lord, how can it possibly take away the minority character? I will make some submissions, my lord, a little later on, as far as the item 63 in the list 1 is concerned. Provision of secular education and admission of non-minorities is not, my lord, as a factor which will be determinative. Provision of secular education and admission of non-minorities, my lord, is not. I'm not going to read out those portions of the judgments, my lord, I've indicated them. My lord, are not going to take away from the minority character. In fact, the entire set of arguments was, we want to be an institution of excellence. So if I reach right over the top and say it's national character, you say this will take away. And that couldn't be right, my lord, because we accept that institutions of excellence will certainly, my lord, be a factor that we will take into account. Then, my lord, recognition as institution of national importance is not a definitive character. Presence of non-minorities in administration and day-to-day management, my lord, doesn't detract in any way from the minority character. Now, my lords, I want to address the question, my lord, of this national character. Let us be clear, my lord, of the 4 points which are not here, my lord, which I want to. My lord, entry 63 relates to competence. Then, my lord, 63, entry 63, is subject to Article 30. Then, my lord, leave that for the moment, because those are the arguments that arise out of entry 63. It relates to competence. These are fields of legislation. And nowhere can we argue, I'm sorry. Was it going very badly? Say I'm going too fast. So much of it has been argued before, my lord. It's not
Really
necessary
meant,
to.
what is meant by national character? I mean, what was there in the constitution? Why did they introduce these words, national character? Because they seem to suggest that national character is in national importance. Right. They are suggesting national importance to be in contrast to denominational.
Right.
That's their whole argument.
My lord, my learned friend will
Right.
elaborate on that. My lord, in any case, the opposite of national character, as it were, importance, my lord, national importance. The converse side of this particular argument is that these are then institutions of super excellence.
Yes.
May I just read that portion, my lord? It was. Now just see the institutions known at the commencement of this constitution. Lord, since your lordships were hurrying up the rest, I thought I was under that aspect as well. Hence the speed, for which I apologize. Now let's have a look at 6. The institutions known at the commencement of this constitution as the Banaras Hindu University, Aligarh Muslim University, and Delhi University. The university shall be established in pursuance of Article 371E and any other institution declared by Parliament and by law to be an institution of national importance. So, my lord, it's national importance. Then I have a look at, my lord, 64. That is on the technical side. And once again, the emphasis in entry 64 is once again, my lord, institutions of national importance. Then a variant of this is in Article 65, that is professional education, promotion of
Actually, Dr. Dhawan, if you see, prior to the 42nd Amendment to the Constitution, entry 11 of the state list, the state list, dealt with education, including universities, subject to the provisions of entry 63, 64, 65, and 66 of list 1, and entry 25 of list 3.
Yes.
So, education was a state subject to entry 63 to 66.
Then it became a concurrent subject.
And entry 25 of list 3, prior to the 42nd Amendment, read vocational and technical training of labor. Therefore, what entry 60, say in this case, entry 63 of the union list did was, once the subject was in entry 63 of the union list, namely institutions of national importance, these two and any others that Parliament may declare, it was taken out of the fold of the state list. So the exclusive jurisdiction to legislate was conferred upon Parliament.
And therefore, not the
Therefore,
state.
it was really something which related legislative competence. What the 42nd Amendment did was, it deleted entry 11 of the state list. It substituted entry 11 of the concurrent list because that dealt vocational and technical training of labor. And now, post the 42nd Amendment, you see entry 25 of list 3, which says education, including technical education, medical education, and universities, subject to entries 63, 64, 65, 66. Therefore, ordinarily, but for entry 63 of list 1, the entirety of the field of education would have been in the state list prior to the 42nd Amendment, and after the 42nd Amendment in the concurrent list. In respect of these two institutions, Aligarh and Banaras Hindu University, and such other institutions as may be declared to be of institutions of national importance, the legislative competence is exclusively vested in Parliament. So the idea of this was, it appears, that in respect of institutions of national importance, there must be some degree of uniformity of the legislative structure, and therefore exclusive jurisdiction is conferred upon Parliament under Article 245.
And not on the states.
And not on the states. That seems to have been the scheme of the Constitution, pre the 42nd Amendment and post the 42nd. Now, what really we want to ask you, and that's something which we have been reflecting on their argument. They see that once an institution is declared as an institution of national character, then calling it a denominational institution would somehow seem to detract from its institution, from the institutional status of a national importance. Is there any substance there? Obviously, you're arguing to the contrary, but why do you say that there's no antagonism between an institution being of a national importance and yet having a minority character?
After TMA Pi indicated that the states will be the unit on which you determine the numerical character.
Right.
There is, of course, a different argument by Justice Umapal, where she said it depends on the statute. But once you have accepted that these are the state subjects, which is linked to the idea of numerical importance, then the states will legislate. If it is reached a level of excellence, a national importance, my lord, is an indication of excellence. That is over and above. It applies to Delhi University, it applies to Banaras, it applies to Aligarh, and a huge number of other institutions. So, my lord, at the end of the day, this was left in the preserve of list 1. So that's the important point here, that they didn't want to, my lord,
so the distribution of the subject, whether it's in list 1, list 2, or list 3, would have no bearing on its minority or non-minority character. Because these are really subjects of legislation and define the distribution of competence between Parliament and the state legislatures on the one hand.
Yes, that's right. And these lists, my lord, are actually on the question of competence.
Absolutely.
Nothing else, my lord. And therefore, if competence vests in the national character or national aspects, my lord, then quite clearly what they are trying to say here is that will be declared. It doesn't go further than say that it is of national character across states.
That's fine.
What can I say?
Really is this. I'll just show you one or two other entries to buttress this interpretation. Once an institution has been declared by Parliament to be of national importance, what would otherwise have fallen for regulation as a list 3 item is taken out of list 3 and then vested under entry 63 of list 1.
Yes.
Take, for instance, entry 52 of list 1. Industries, the control of which by the union is declared by parliament by law to be expedient in the public interest. So once there is a declaration by parliament within the meaning of entry 52 of list 1, it goes out of industries which fall within the control of the state governments. See, for instance, entry 24 of the state list. Industries subject to the provisions of entries 7 and 52 of list 1. Entry 52 of list 1 says those which are declared by parliament. So once there's a declaration, absent a declaration, it still continues to be a state subject. Once there's a declaration, it ceases to be a state subject and it becomes a central subject. Likewise, in the case of entry 66, these national institutions of national importance, if there's no declaration by parliament, we are not dealing with for a moment AMU and BHU. If there's no declaration by parliament within the meaning of entry 63, it's still covered by the state's power to legislate by entry 25.
A significant point would be, does this trump Article 31 or not? And in all, whether it's the legislation of the state or whether it's legislation of national.
Conceptually, it should not, because all lawmaking in pursuance of the jurisdiction under Article 245 and 246 subject to the entries is subject to the fundamental rights.
It must be below.
So the fact that something is of national importance may not at a constitutional level be antagonistic to the concept of it's still yielding to minority rights. Whether there are minority rights here is a separate issue. But at a conceptual constitutional level, you can't accept that merely because it is of a national importance, therefore there cannot be minority control over the institution. That wouldn't be the scheme of the Constitution.
That's right, Mama. Because what happens, national importance is there, as I indicated, as a sign of super excellence. So that is there. But there is nothing within the competence that says it will trump Article 31. Nothing. Their argument, my lord,
yes,
is that once you enter into the arena of national importance, then instantly it cannot be a minority institution. That's their argument. There's nothing to suggest that it can't be. Fundamental rights will trump the issue of competency. And this subject to the provisions in the state list, my lord, is writ large over many other entries.
See, for instance, entry 54 of the union list, regulation of mines and mineral development, to the extent to which such regulation and development under the control of the union is declared by parliament by law to be expedient in the public interest.
Correct.
And then entry 23 of the state list, regulation of mines and mineral development subject to the provisions of list 1 with respect to regulation and development under the control of the union. So once parliament makes a declaration under a list 1 subject, then that is to that extent denuded from the power of the states under list 2 or the list 3 as well.
Noting the scheme of 245 and 256, that is all on the question of competency. But their argument goes one step further. That is, if it is of national importance, it can't have a minority character. That's the essence of the argument that they have made on public importance, national importance. Article 30, my lord, cannot be read out of existence on an issue of competency. And nothing in these schedules, my lord, of whatever nature, whether it's public interest or whether it's national importance, every single statute in any of the lists will be subject to 30, as indeed Article 19, 21, 26.
Well, I just wanted to mention, Malat's Dr. Ambedkar, in the context of institution of national importance, said the following. With regard to subsequent part of the entry relating to any other institutions declared by law by Parliament, it seems to me that it is desirable to retain those words because there might be institutions which are of such importance from a cultural or a national point of view and whose financial position may not be as sound as the position of any other institution and may require help and assistance of the science.
Where do we get this? In the
Yes, Dr. Ambedkar, Madam, with the draft constitution.
We have expected in the submission also.
It's there.
And not essentially expected.
This is
Volume?
expected in my submission also later.
4B118.
National importance because it symbolizes the ethos of the constitution where.
Therefore, the parliament has been given the power.
That's correct. It can't be, Madam, that merely because it's a minority, it will not be of national importance to give it the status of a institution of national importance. It can't possibly be. Anyway, I'm sorry, Madam, I interrupted.
What
Cultural importance.
the importance of this is when can the minority character under Article 30, when does it become defeasible? Never, my lord. In fact, Chief Justice Sikri goes to the extent that even the amendment power must preserve the nature of the minority.
Let's go to your page
That's
19.
the real point, my lord, here. What is it? It's competence, exclusion of competence, and then, my lord, subject to Article 30, subclause 1. It can never, my lord, fundamental rights can neither be waived nor are they defeasible. And that premium, my lord, on fundamental rights cannot be taken away by the issue of competency. That's basically, my lord, the argument. How they distribute the power, my lord, between the center and the state is different. Because even in 62, the institutions known as National Library, Indian Museum, etc., declared by Parliament.
Dr. Dhawan, perhaps, what Basha said was, Basha's logic was that you could not have set up a university whose degrees were recognized. And because you could not have set up a university whose degrees would be recognized, you followed this route. And because you followed this route, necessarily there is a surrender of your, they don't say surrender. Therefore, this is not established by a minority. That's the logic.
Used in Aziz Basha in only one context, property. The word surrender is used in only one place. Just find that.
Yes, only property.
But
Only property.
the other side has gone beyond Basha, reasoning of Basha.
They say there was a complete surrender.
They have referred to the antecedent facts that repeatedly there was the different point of views, and by choice they accepted certain conditions which indicate that they gave up their status as a minority institution,
Yes,
even if we apply the dictum in doctrine as exists post the constitution.
yes, that's right. That's right. But they've elevated national importance to be a denial of 30.
So this is a
That
separate
may not,
argument.
that's a separate issue altogether.
Fine. Now, my lords, if you look at 62, 63, and 64, once again, it requires the declaration of national importance. And when it comes to, my lord, state list, there are many provisions in the state list that make it subject to the union list. This is a question of division of power, nothing more. Now, may I come back to my
Yes, page 19.
which one do I have?
तो एडमिनिस्ट्रेशन में थोड़ी दिक्कत होती है.
Lord, the factors, I hope I made myself clear on factors that go to the root and
Yeah.
factors that are not determinate. Age, my lord, is not determinate. admissions are not determinative. In fact, St. David's case that is cited there, they had the right to grant degrees, but they said because there is no statement that it is a university, we won't treat it as a university. So the converse proposition arises from St. David's in Aziz Masham. Now, my lords, I also wanted to emphasize, my lord, that the absence of statutory declaration of minority status is not determined. Think through to them in any way.
It is a national-
Ships will come to PDF 19. 4.5.
Yes.
So, my lord, Sir Syed Ahmad, because this is the movement of the community, not just the negotiations. Sir Syed Ahmad, members of the MAO College Committee, trustees of MAO College, and members of the Muslim University Association were all Muslim. The reserve fund of 30 lakhs was substantially donated by members of the Muslim community. The historical antecedents clearly show the predominant role of the Muslim community in founding AMU. The intention of the founders to establish AMU for the benefit of the Muslim community is also unequivocally reflected in historical documents, including the debates to the 1920 Act. The 1920 Act must be read as a whole. And we find that even if, my lord, the minority character, we take away the declaratory provisions, it will still be established from the document as a whole, the Act as a whole, that it is of minority character. Because of the various provisions, which are provisions of continuity and provisions which repose a certain amount of faith in the Muslim community. No. Then, my lord, come to sub-Roman 5 or 4.5. 3 out of 4 officers of the university, this is in the 1920 Act, Chancellor, Pro-Chancellor, and Vice-Chancellor were required to be Muslim. If we're looking at the 1920 Act, the court being the supreme governing body were required to be Muslims by law. That is, my lord, again, we're looking at the 1920 Act. The 2 other authorities, Executive Council, Academic Council, were predominantly Muslim because the majority of them had a seat in the court. Then, my lord, the others that I've already referred to.
Mr. Dr. Dhawan,
Well, I prefer Mr. Doctor was 50 years ago.
that we have a continuing dialogue since the time when you were arguing Ayodhya before us. But we have to rise today at 3:30. In the highest traditions of the bench, 2 of my colleagues are going out of town for a wedding this evening and coming back at 1 o'clock at night so that the CB hearings are not disturbed. So I thought I'll just give them a little more time to reach the airport. And,
Noble cause.
but they said that they will not, allow the CB hearings tomorrow, Justice Suryakant and brothers
That's very
Satish Sharma, that we'll come back in the night so that we are here on duty tomorrow morning. So we'll rise right now. Tomorrow morning we'll continue.
elaborate.
Dr. Dhawan, just one last thing. If you could maybe dwell on the administration aspect, because they have dealt quite substantially that administration was never vested in
It's in
Muslims
the,
because.
in the next part of the note, and Mr. Sibbal will
All
deal with
fair
it more elaborately.
Fair enough.